So, good afternoon, everyone. Welcome to From Policy to Practice, Mastering the Modern Employee Handbook. Today is sponsored by the City of Glendale. My name is Anna. I'm the digital media and event strategist here at the California Employers Association. And we just want to thank you for taking time out of your afternoon to join us for this training. Before we get into today's content, just a couple details to go over with you, especially if this is your first time joining us. So as you see, your audio is muted for today's presentation, but there are going to be lots of opportunities to engage during the training as you're already doing so in the chat today. If you do have any questions about the content, you can enter those into the Q&A box at any time, and we will do our best to address those as we go. While one trainer is delivering the content, we'll have another one managing that Q&A for you, and you'll meet them in just a moment. Handouts for this training will be dropped into the chat box shortly. So once you see the PDF icon and file name pop up, you can just click on that and it should download locally to your drive. I will be watching the chat box the whole time. So if you have any issues accessing that PDF, please just send me a message and I'll be more than happy to troubleshoot that with you and make sure that you get it one way or another. No worries. So as you logged on, you saw that this webinar is being recorded and the team at City of Glendale will be reaching out when that will be available for review. So make sure you are active on their email list to be notified. And then last but not least, we will be inviting you to share your feedback at the end of today's training by participating in a brief survey. It's about 5 questions. It generally takes about a minute to a minute and a half to complete, but the feedback that you share with us in those 5 questions, we really do take to heart here at CEA. We share the feedback with our partners over at City of Glendale, and we collectively make sure that we are meeting and hopefully exceeding your expectations with trainings like these. And this is also your opportunity to suggest trainings that you'd like to see in the future. There is a question for that. Again, today our training is brought to you by the City of Glendale, and today we're joined by Sevik Deshoyan, the Economic Development Coordinator, to share more about the resources available to employers like you. Hi, Sev.
Thank you, Anna. Hi, everyone. I want to, first of all, thank you on behalf of City of Glendale's Economic Development Division for joining us today. As usual, very happy to be working with California Employers Association to bring you those webinars that we do. But before we get into the main topic, I wanted to quickly talk about what we do here at Economic Development and how we can help either start or grow your business in Glendale. So our division really is basically working on 2 main items at all times. And those 2 items are business retention and business expansion. And the way we approach those 2 goals is through our core economic development services that you're seeing on the screen at the moment. So services such as site selection assistance, where we can help you find the ideal location for your business, whether it's expanding or coming to Glendale as a new business. Business concierge service is another one we offer where we can help with expediting your permitting process. Marketing and social media assistance is another big one where we can help you basically put your name out there, put the name of the business out there on our social media outlets and different platforms that we have available. And facilitation of business resources where we can help connect you to local, state, and federal resources. One of the latest services that we've also launched in collaboration with California Employers Association is our free HR hotline, available to all Glendale businesses, Monday through Friday, 8 a.m. to 5 p.m., where you can basically give them a call and get all of your HR-related questions answered, from basic, what the minimum wage is, all the way to industry-specific ones. All of those services I mentioned are completely free. Even the other ones that I didn't really specifically mention that are on the screen are completely free. And if you're interested in utilizing any of them, I would highly encourage you to visit our website at chooseglendaleca.com, or you can contact me. I'll be more than happy to walk you through all of our services and how we can customize each one of them based on your needs. I'll leave my information in chat right after this. And with that being said, I'll now pass the mic back to Anna to get the main portion of the webinar started. Thank you.
Awesome. Thank you, Sevik, and your entire team over at Glendale for all the hard work that you do for your employers. And now I'd love to introduce our trainers today. So today we have Astrid Servin, our HR Director, delivering the content, while Virginia Young, our HR Compliance Director, will be managing the Q&A. So you are in great hands, and I'm going to hand it over to Astrid.
Thank you so much, Anna, and thank you, Sev, for that introduction. And happy to partner with the City of Glendale. We're really excited to offer this webinar today. A little bit more about who we are. You've heard of our company here, California Employers Association. We are an HR consulting company. We like to pride ourselves by saying we provide businesses with peace of mind. So you have the 800 number you can call into, and that's a great resource. You may have gotten myself or Virginia or some of the other HR advisors here when you give us a call. We love to talk to you all about anything HR related, up to 15 minutes per call. But if you need a little bit more than that, if you need more than phone support and you're looking for more of a hand holding, then you may want to give our membership a try. So you can visit us at employers.org, and you'll see that we provide things such as employee forms, policies, guidelines, fact sheets. We even have a do-it-yourself employee handbook, which is what we're talking about today. And then we offer lots of different trainings as well, personalized training for your business. So if you need a little bit more, like you said, even on-site assistance or union avoidance, that kind of training, we provide that kind of service for you. Just visit us at employers.org. What we are not is a law firm, though. We are not an HR law, I'm sorry, we're an HR consulting company, not a law firm. So this presentation should not be relied upon as legal advice. This is the stuff our attorneys make us say. We want you to consult with your own attorney about any issue of legal significance to you or your company. A lot of times we kind of help you get to the point where you need to speak to your attorney, which saves you a lot of time and money. Because they can be very expensive. So a lot of times employers come to us, we talk about and discuss things such as this morning I was talking to a business about a layoff, and they were thinking of either a reduction in force or a layoff, and we talked about all those things, and then he needed to do a severance agreement, and that got to the point where he needed to go to his attorney. So once again, we're not a law firm, but we do help you with a lot of employment law related things. And this presentation, we're going to talk a lot about laws, but please do not rely upon this as legal advice. This is educational. So the stuff we'll cover this is such an important topic to talk about, first of all. So kudos to you for logging on, because we all have a handbook. More than likely, we have a handbook in place, but we don't review it or take the time to really talk about the benefits. And with benefits also comes risk, because the handbook can help you as much as harm you. If your handbook is old and outdated and you are not well versed in this handbook, it can actually harm you. So we want to make sure that we're using it in a very productive way, in a smart way, because it does provide lots of benefits to a company when we learn about it, when we know about it. We're going to talk about the essential provisions, what to include, what are the must-haves, what are maybe just best practices. You don't legally need to have these things in place, but it's a best practice and why we recommend that. And then we'll teach you how to review and edit that handbook, ensure that it's compliant for 2025. And then we'll talk about those annual checkups, because if you've been in California doing business, we know that sometimes even mid-year, but at least annually, we should be looking at those handbooks to ensure what are the new laws, what are the new policies. And employers.org here at our website, we keep up to date with all those. So if you get an actual CEA handbook, we provide those updates annually for you. So you can just go in and make those changes annually, which is a great benefit to have. And those are provided free for anyone who purchases that template. So let's start by talking about the benefits. There's quite a few benefits here. The number one rule is that it sets the positive tone for your business. We want to start the employment relationship right. We want employees to enjoy where they're working and be familiar with the company that they just signed up for. They did a lot, right? They had to apply, interview, and you hired them. We want this handbook, when you provide it to them at orientation, to set the tone. We want it to be a positive start already. Once they see that handbook, all the benefits that you offer, all the wonderful things that you offer are in this handbook. You cared enough to have a handbook that's compliant and up to date for them. So let's make sure it has that positivity there for them. Number one is a confirmation of at-will employment, which we'll talk about a little bit more in detail. But you want that confirmation of at-will because California is an at-will state, meaning either party can end that relationship. We don't have a contract with you. We are in at-will employment. So we want that statement right off the bat, and that handbook is a perfect place to put it in. And then it's also an explanation of benefits. We want to make sure that employees understand that we have our explanation of policies and benefits, both. We want to remind them that these are the policies that we follow in this company, and at the same time, we're setting those expectations for employees. This is what we do tolerate, what we do not tolerate, which kind of goes in connection with a lot of other things, such as harassment and discrimination. There's legal things that we need to provide, and we'll go through those as we go on through the webinar. And this is a good place to set those expectations right off the bat by putting these things in place. It serves for uniformity and consistency, which is terrific, especially if you're a big company. And it's not just for big employers, even if you're a small employer with different departments, we want to make sure that we're a unified voice, that our company is not treating employees differently, because now if we do that, we're setting ourselves up for a possible discrimination claim. So we want to make sure that the attendance policy, whatever we follow, is the same, or that the vacation policy, we're all in and the understanding that what that is. There may be differences in certain departments, but we're laying them out and spelling them out in the handbook. And we're all following the same sort of standard in that handbook. It's a great defense to harassment claims and discrimination claims, retaliation claims. California requires you to put harassment policy, which we'll discuss in the future slide, about what you have to include in a harassment policy. Well, this is setting the tone. Again, we're including it in the handbook. We're giving it out to our employees. Employees are signing off that they understand that we do not tolerate harassment or discrimination in the workplace. And then it's going to give them a path as to how to alert a management if something should happen. If there's a concern or a complaint that I need management to address, we're providing that pathway in that handbook. And then finally, union avoidance. Most of you businesses that are logged on are probably not a union environment, and we like it that way. We want to try to avoid that. And so the language we include, we need to be careful what we say and do not say, and we'll talk about that towards the end of this presentation. But it does serve as a way for employees to have an outlet and report. We talk about open door policies. We talk about if there's a disagreement, what to do, if there's discipline, how we do all that. And that is good. We need that dialogue. We need employees to be well informed of what they need to do in this company in order for them not to then go out and talk to others about forming a union. We like our employees to know that we listen to them, that we have an open door policy, that it's a positive place to work, and there's outlets for them to discuss these things when there's problems. So we want that union-free avoidance, and that's the handbook is going to serve for all those purposes. Now, what to avoid, because like I said, just as easily as it can benefit you, it can also be somewhat risky not to follow the handbook, not to be consistent. And now suddenly this manager is following the handbook and the other manager is not, and employees talk, and we can't prevent them from talking about work stuff. So when they talk, they're going to realize that this manager is maybe out to get me, and that's why they're enforcing that rule, and this other manager is not. They're nice. And so because of that, we want to make sure we avoid not following the handbook. We need to train our supervisors, managements, our leads to all be consistent in how we apply the handbook to employees. Not reviewing the handbook can get you in hot water, because if we're not reviewing it, if we're not updating it, then it's an outdated handbook. And that's also, again, a big high risk for a company. If we're saying that the sick leave policy is X or the vacation policy is X, and we are, that's not true, because it is no longer compliant. Maybe it's an old sick leave policy and not even California compliant anymore. That can be difficult to defend. So we want employees to be well informed of what the current policies are, what the updated leaves are, what the updated, perhaps jury duty or bereavement leave, if those things have changed, that we have the actual policy that's updated in place. We don't want to download a random version from the internet or borrow one. Now, you may have inherited an old handbook, and that's sometimes something you have to work with, but be mindful that these generic versions of handbooks that are floating around the internet or that you borrowed from one may not be California compliant. As you know, doing business in California, we're very specific. California has so many rules and laws that we have to follow. We want to make sure that you have the most current one that is compliant in California, or else you're already going to be in hot water by not having the most up-to-date handbook. I can tell you there were updates in 2025, there were major updates in 2024, and more than likely we will see some updates in 2026. So we need to be updating these handbooks annually. So creating your handbook, where do we kind of start off? We want to assess our current policies. I mentioned a few: jury duty, bereavement. Some of these policies may have changed. We had this horrible thing called COVID-19 that happened, and many people changed the way they did business during COVID. Do those policies still exist? Do we like some of them? Some people went to work remote and some employees stayed working remote. Some are working hybrid. So assess your current policies to see if they make sense still. Are there new policies that are required in the coming year? Are businesses change? Remember, you're allowed to do that. Business demands change. We can change policies. Just make sure that we're giving employees notice and that we're being mindful and that we're doing this policy in a compliant way. ChatGPT is great for creating a policy, but you want to make sure it's compliant. You're checking in. Giving us a call into the hotline would be a great time to do that, and just checking to make sure this policy I wrote, is it compliant? Is it okay? So begin the drafting process. And the ideal handbook is going to have policies that are carefully and clearly worded. You want to make sure it's written in a way where employees are going to understand it. And when it comes to drafting your policies, you want to try to avoid legal jargon as much as possible. We don't want the here to, there to, aforementioned policy, all that kind of stuff confuses employees. We want to make sure that it's clearly worded, the employees understand what they're talking about, and then it's an accurate reflection of your policy. Is it current? Are we talking about the same thing, or is this an old policy from 10 years ago? So that's why it's important for you to update that at least annually. It's consistent with applicable legal requirements. As I keep mentioning, laws change. So like sick leave, bereavement, those have changed in the last few years. Or updates to the CFR policy, which we'll talk about soon. Those things need to be ensure that you've updated them in your handbook. Again, understood by the audience, and it's not a snooze fest. We don't want it to be completely boring and painful to read. I understand employees are not reading their handbook, but if they should need it, and when they need it is probably a time where it's usually a difficult situation they're dealing with, we want them to be able to go to that section and easily understand that. So make it user-friendly. That's my advice to you. So do you have a handbook or do you have a policy manual? Sometimes we call them policy manuals or manuals, and we want to make sure we get the wording right. A handbook is generally applicable policies that are included on there. It's abbreviated coverage. It's for everyone. It's going to include a lot of the stuff we're going to talk about today, where a policy manual is more for procedure. So step-by-step things on how to do things in your procedure, in your day-to-day operation. It's going to include more detailed coverage and forms, and it's typically for managers and supervisors. That's who's usually handling these policy manuals, if you will. So a handbook is going to be for everyone. We're going to get a signature from everyone, from every single employee, even if they start mid-year. We're giving it to them, hopefully at orientation, and getting a sign-off on that. All right. So let's talk about the essentials, what to include as basic or as options. We're going to cover the basics. We're going to avoid confusion. We're going to include what's required and what are best practices, and then other options to consider. We're going to review kind of a lot of things high level. You're going to get a copy of these slides, so don't worry, you can always refer to these slides and reference them, and then you have the benefit of the HR hotline. So give us a call if something was confusing or you didn't quite get it or you're not understanding why it's a best practice. Give us a call and we can talk about that. All right, let's see. So if you've been in management and have had employees, you probably have heard things such as, you can't change my job description, or do we have to give a 2 weeks notice? I mean, these are things we get calls into from managers like yourself sometimes. If my coworker makes me uncomfortable, what do I do? My friend who's a lawyer says, you have to give me that day off and pay me, sometimes double time or time and a half, or you have to pay me an extra 8 hours for the holiday. Do I get paid for the holiday? I thought it was illegal not to pay me for the holiday. How much vacation do I get each year? What if I quit before the end of the year? Do I get my vacation paid out? What if I don't want to take my breaks? Do I have to? Your handbook should be able to answer all these questions, plus more. A lot of times when Virginia and I will get a call into the hotline, we'll say, well, what does your handbook say? A very common one is, do I have to pay them for the holiday? Or how much do I have to pay them if they work on the holiday? And we will say, well, what does your handbook say? Because it will depend on what your handbook says. Some things are optional for employers in California, and so your handbook is going to answer that question. And if an employee files a claim with the labor commissioner, or they go file something, that's where the answer is going to be found, is in your handbook. Sometimes it's a California compliant law that we have to follow, and sometimes it's an optional policy that you have to be consistent with and write down. So again, the handbook would be a great place to reference and show that you were in compliance. All right, so some important statements. You want to remind employees of the at-will status. We mentioned that in the beginning, and that's very important. For employees to understand that employee or employer can change the terms and conditions of employment, meaning this is not a contract situation where we have you for a specific amount of time. That includes that you can terminate, demote, transfer, reassign without advance notice or cause. It's very important to include that so employees understand that any one of us can be the moving party, you or I. It's not subject to change except in writing. So this at-will statement is not subject to change unless it's in writing by the employee and expressly designated company representative. We recommend that company representative be a very high-level executive, such as a CEO, and not very many more people than that. The owner, the CEO, the president should be the ones that can change the at-will status. And that protects you, company, from these rogue possible leads or managers who might say things like, don't worry, I hired you for the next 3 months. Well, what if something goes haywire and you don't want to keep them for the last 3 months? We can point to the at-will and say that manager didn't have the authority to do that. And it's going to include an integration clause that supersedes prior agreements. So we're going to include something like, you know, there was an old policy and the employee says, well, I like that old policy from way back when, let me use that one. Well, no, this new handbook, this supersedes anything that was prior, any kind of prior agreement, maybe a prior manager made with you. This is what is the law of the land today. And we want that signature from the employee because that's going to make a big difference. Let's talk about discrimination and harassment prevention. I know you all have your employees trained, right, on harassment prevention. We've all provided our employees with 1 hour training. We've provided our supervisors with 2 hours of training every 2 years. Well, we also, another big law that comes along with that is including a policy on harassment and discrimination in your handbook. If it's not in your handbook, it is required, so you have to have it. It's just a great place to just put it in there. And we want this policy to state that we don't discriminate against employees, that our decisions that we make, whether they be disciplinary or termination, whatever we lead to any adverse action, is based on work-related factors. It's based on work performance. If there's attendance issues, we followed our attendance policy. If there's safety violations, we followed those rules. If there's any kind of violation of company policy, we followed steps to do that. And you should know all of the protected classes because that is really important too, to be familiar, at least familiar. I know there's a lot of protected classes, especially in California. We want to somewhat be familiar. They're all going to hear about those protected classes because we train them every 2 years in that hour training that they receive. But your managements or supervisors should be somewhat aware. And really, everyone is protected in California. So just think about that. It's important to know these protected classes because we take them into consideration whenever we're going to take some sort of adverse action against an employee. Sometimes that may matter. You may, for a very non-discriminatory reason, be doing something such as a layoff or a termination or a discipline. But if we are aware of the protected classes, that sometimes weighs in on our decision in what we're going to do. So be aware, and also employees can state, I feel uncomfortable, or people are discriminating against me, or I feel harassed based on my protected class. So be somewhat aware of these, know that they're out there because there's quite a few of them. So I talked about our policy that we need to include. California, we have a template here, and CEA has a template that you can download, but we want to make sure that we include at least the essentials, and our policy does include the essentials. And take this screenshot here and go through and make sure that you have that in your policy, whatever your harassment policy looks like. We want to make a statement that harassment is illegal and it won't be tolerated. We're going to list all those protected classes, which are updated for 2025. Make sure you have all of them. That the law's prohibition of coworkers and third parties, as well as supervisors, from engaging in this prohibited conduct. There's going to be an anti-retaliation statement, and you do have to have the Civil Rights Department and the EEOC's contact information with their phone number and training links on there as well. Your policy is going to include a detailed complaint process, as you see here on your screen. It's going to go through all the steps, and make sure you know these steps because you are saying that you're going to follow them should an employee have a complaint, have a concern comes up in the realm of harassment or discrimination. You have to follow these steps. You've said it in your policy, and it's also California law that you have to follow that. Remember, if you have 10% or more of employees that speak a different language other than English, you do have to have this policy translated. We have it in Spanish as well, but if you do need another language, you'll need to find a way to translate that policy in that language if 10% or more of your employees speak that language. Let's talk a little bit about leaves because we want to include the important leaves in our handbook as well. Again, many of you may not know exactly what leaves apply to your employees. So having a nice place to have them all there and reference, and again, this is what your employee is going to do. Hey, I'm sick, or my husband's sick, or my child is sick, or my significant other who's not related to me is sick. What rights do I have? And they're going to look into your handbook. You want to have at least the sick leave policy. We know that in California, we do require California is required to provide 5 days or 40 hours of paid time off of job protection to all employees to address their own health needs or that of their family member. Remember, be aware of any job abandonment provisions. Be aware of those 3 days you're out of here. If they're using sick leave for that, may not be a way for you to just terminate on that 3rd day if they're using sick leave, because that is job protected time off. So whenever they're using the sick leave, we cannot use it against their attendance policy when they have this available to them. There's different ways to provide sick leave, as you may already know. There's the accrual method where we're doing 1 hour for every 30, and you cap it at 80. You limit the use to 40, which is somewhat confusing to employees because they're seeing that they have more than 40 available to them, or that they've accrued more than 40, but they are only limited to the use of 40 in the year. So if you're doing the accrual, again, handbook, great place to explain how the accrual method works. This is the choice that we're choosing as a company to have sick leave, and this is the way it works. Lump sum method, and you can do it this way. You can instead of doing the accrual, grant a lump sum of 5 days or 40 hours each year, and that expires at the end of the year. You're not doing a rollover the way you are with the accrual. It starts over either an anniversary year or on January 1st, whatever you choose to do. With both plans, you can require employees to wait 90 days to use that paid sick leave. How does any employee know that? You're going to put it in the handbook. That's why we're putting it on here. Make sure your handbook states that. And then it also states that it's not paid out at termination unless it's part of a PTO plan. And the employer cannot retaliate for using sick leave. You want all those statements on there. The PTO plan is the 3rd way you can provide sick leave to your employees. The PTO plan is a paid time off where you combine both vacation and sick leave and make that available for the same purposes as a sick time. You just have to be careful because once you combine the vacation and the sick, now you have to pay out that PTO at termination. So sometimes employers like to do this and they like to combine them in a PTO. If you're going to do that, I would advise you to give us a call at the hotline and just kind of weigh the pros and cons of having a PTO plan, because there's definitely a lot of cons. There's some pros as well. But if you are going to go that route, we want to make sure that you're well versed on how that PTO plan is going to work. Be aware of local sick leave ordinances. You're in the LA area, so if employees where they work, if you have remote workers, there may be different sick leave ordinances that are higher than 5 or 40, and there's quite a few that have. We have a bit.ly here that you can follow. You can also log on to our website. It's there under HR forms. I believe it's a free form that you can use and see what the local ordinances have for both minimum wage and for sick leave. So be aware, especially when your employees are working remote, where the employee is working physically is the laws that you have to follow. So make sure you're aware of those as well. The other one we want you to include in your handbook is the PDL, the pregnancy disability leave, because this is going to be a leave that's employees are eligible for from day one. They do not have to wait. So this is going to be okay for all employees who become pregnant. So it's going to be if you are an employer with 5 or more employees and or had 5 or more in the past year for 20 or more consecutive weeks that you have to provide PDL. The eligible employee has to show some sort of substantiation from the healthcare provider stating that they cannot perform one or more of the essential functions of their job without undue risk to themselves, their pregnancies, or their pregnancy's successful completion. So that's the statement that they have to have. If they have that, and it can be before, during, and after pregnancy. Well, not before, during or after. So if they're disabled due to pregnancy and they're having morning sickness, for example, that is something that's covered. This can be, again, after, I guess it could be before as well, if they're having some sort of complication or something related to pregnancy, then that can be something they're eligible for. How much do they receive? And this should be in your handbook. They're going to receive up to 4 months and the equivalent of weeks or days or hours. And you're going to track that, because if it does happen before or during, you're going to be tracking that time off. An employee is only eligible for PDL while they're under the doctor's care. Once they are no longer under the doctor's care, they are no longer eligible for PDL, even if they have PDL available to them because they didn't take the 4 months. They're only allowed to take it while they're disabled by the doctor. So it may not look like 4 months. It can be up to 4 months. The majority of pregnancies are not going to be that long. Again, it's related to per pregnancy, not per year. So there is no limit. If an employee loses the baby and then they become pregnant again, this would still apply. You can use it all at once or intermittently, and you can require employee may choose to use sick leave if they want. They cannot use vacation or PTO, and then the time needed must be, again, certified by that healthcare provider. The other one we want you to include is the CFRA, or the California Family Rights Act. This is important because it's going to apply to most businesses. It's going to provide up to 12 weeks of unpaid leave with benefits if you have more than 5 or more employees, and if they've worked with you for 12 months, and in that time, in the prior 12 months, they've completed 1,250 hours. So roughly full-time employees will be eligible for this. And this is going to be for a wide variety of reasons, which you should also include in your handbook. The birth or child, I'm not going to read them all to you, but basically, if it's for the birth of a child for baby bonding purposes, not for their actual disability. So CFRA is not going to cover a pregnant employee while they're disabled. It's only going to cover them for baby bonding purposes. So once the child is born and they are no longer disabled, then the CFRA will kick in. And the way it normally works for a pregnant employee is they are under PDL first, that pregnancy disability leave. Once they are no longer disabled by that child, that doctor no longer disables them, then they are able to take the CFRA to baby bond. That's typically how it looks for a pregnant employee. Now, it can also be taken for their own serious health condition or to care for a family member or a designated person. Again, these are the reasons why your employee is going to look at their handbook to see if they're eligible, if they apply. So make sure you know the rule for it as well. For my larger employers, if you have 50 or more employees, you're covered under FMLA, which also provides 12 weeks of leave in a 12-month period. Now, if you are a larger employee, you are designating both leaves at the same time. If both are eligible for CFRA and for FMLA, we're designating them both concurrently. They're not eligible for 12 weeks of CFRA and 12 weeks of FMLA. The only time that's going to happen is if the reasons are different and one is not covered and the other is. So make sure that we're listing out and spelling out the reasons why we're taking FMLA and why we're taking CFRA. And if they link up, you can use them simultaneously. Pay attention to the work at a location of 50 or more employees in a 75-mile radius, because you may have quite a few employees that work in a different state or in a different county that's far away from where you are, farther away than 75 miles, and that employee may not be eligible for this leave. So that matters. So pay attention to these kinds of requirements here. The other one I wanted to mention is bereavement leave, because this is fairly new. Employers with 5 or more employees have to provide 5 days of unpaid bereavement leave. So this is a requirement. Now, you can provide part of that time as paid. You can provide all 5 days paid or partial. The common one is 3 days of paid bereavement. But just remember, California does require for you to allow them to have 5 days. So it can be out of the 5, 3 are paid and 2 are unpaid. make that clear in your handbook. This is why it's important to spell it out and put it on there. And then lay out the groundworks and how an employee is eligible for that bereavement leave, that they have to be employed with you for 30 days, they have to use it within 3 months of the date of death. If we're going to have them do any kind of substantiation, we're going to list it out on there. Just a few more things for bereavement leave. We won't cover it all, but just know that this is something that you want to put into your handbook as since it is a requirement. There's more protected leaves. There's additional ones as we're living in the great state of California. So just know that if an employee says, I need time off for something, I think I'm protected, they probably are. You're going to want to check in with the handbook and then give us a call at the hotline. That's what's the great benefit of having this hotline is you can give us a call and say, my employee just said I have to give them paid time off to go to bone marrow or to an organ donation. And we're going to say, yeah, you do. And it is paid. And so we want to make sure we're spelling those things out. But we'll always ask you how many employees, how long have they been there. We're going to check for eligibility. It makes it a little bit nicer to go through it a little bit faster. But again, these things, if they apply to you, depending on your head count, you may need to include in the handbook and have it on there. Let's move over to the wage and hour land that we want you to include in your handbook as well, because we need to pay our employees and we need to pay them correctly because they will be the first to point out if we do not do that correctly. So we want to make sure we just have the big things that are going to matter to you in your handbook. They're going to save you a lot of time and energy, and if they file a claim, may save you lots of money. So the first thing is defining your workday and the work week, because we want to define it for overtime purposes. Overtime is, well, we'll cover overtime in the next line, but California defaults what your workday and work week is. And if you want it to be different, I saw some people in hospitality on here, and it may be in certain industries, it may make sense for us to count our 24-hour workday and our work week differently. So you decide, and if you do want it to be different, it needs to be spelled out in your handbook. So a workday is any consecutive 24-hour periods beginning at the same time each calendar day. The presumption in California is that 12:01 to 12 a.m. So if you want it to be 7 a.m. to 6:59 p.m., you can do that, but you need to spell that out in your handbook. Okay, and again, it matters for overtime. I used to work at Target way back when, and we had an overnight shift, and sometimes we get into that trouble of, do they get paid overtime when they're working at 10 p.m. to 6:30 a.m.? 2 different work days. We don't necessarily, and maybe they will go over, time 10 p.m. to 8 a.m. Do we owe them overtime if they're 2 different work days? So may not matter in your business, but it may if you're working overnight shifts. Work weeks is any 7 consecutive days, starting with the same calendar day each week. Same sort of logic here. The presumption is Sunday to Saturday, so you can make it different. If it makes more sense for you to have a Monday through Sunday work week, then spell it out in your handbook. We do need to give employees a little bit of notice before that, so that if we're making changes to that, at least give them that pay period of notice if you're going to do that. And this is why it matters, because overtime is paid at time and a half for hours worked over 8 hours in a work day, which is why that work day needs to be defined. And then it's also for over 40 hours in a work week. And then it's also for the first 8 hours worked on that 7th consecutive day in a work week. So even if an employee isn't working quite 40 hours in that work week, but they're working 7 days in a row, if those 7 days happen to be in 2 different work weeks, you don't owe them overtime, even if they were consecutive. But if they are, then we do need to owe them overtime. So be careful how you define the work week, and work day, and that you're defining it, and that you're paying overtime accordingly. Remember, double time kicks in after over 12 hours in a work day, and then after 8 on that 7th consecutive day. First 8 is overtime. After 8 is that double time. You want to put meal and rest break policies in your handbook. It's that low-hanging fruit for plaintiff's attorneys. If you have seen class action lawsuits, if you have seen PAGA claims, if you know what PAGA is, you know what I'm talking about, because they will look to see if you've given employees breaks and meal periods. So we're going to talk about that. We want you to put that in the handbook. It really shows that the employer understands the laws on breaks and meal periods, that we're training our supervisors, our leads in this subject, and our employees. Our employees need to know what they should be doing as well. And we're signing off that we have policies on this and that they understand it, because they continue to be these costly wage and hour claims. So you want to include a section in the handbook that, and we're going to provide you that, you can just include that same little slide that we have in your policy. This is for our hourly folks, not for our exempt employees. And again, train your managers on enforcing this strictly. For rest breaks, you're seeing a table here of how that works, depending on the number of hours, how many rest breaks an hourly employee is entitled to take. And remember, an employer has to authorize and permit the employees to take 10 net rest time, 10 minutes of rest time for every 4 hours worked. And we say net rest time because sometimes an employee has to go through a security check or get to a long area before they actually can rest. And if that's the case, you're going to want to add a couple minutes to account for that. A rest period should be in the middle of a work period. We shouldn't be doing these things where we're adding them to our lunch period. I know that's popular. Or, hey, I'm going to leave 10 minutes early. I'm going to take my 10 minutes at the end. It's not, it's, you know, again, it's frowned upon by the labor commissioner, really wants them to be in the middle of a work period. You don't need to record rest breaks on time records or have them clock in and out because it is paid time. Now, if your time clock has a way to just log it, you're just doing it for purposes of logging, you're still paying them, then you can do that. Just be careful that employees are following this policy consistently. We cannot require anymore for employees to remain on the premises. So be careful if you have policies that say you have to stay in place. If they order, you know, their drink on an app and they can get there and back in 10 minutes, you know, good for them. You have to allow it. If you do not give them this rest break, you do have to pay 1 hour penalty. And we're including that in the handbook, that we understand that we know about this. Meal periods, same logic here. You know, we have to provide this, permit a 30-minute meal break if an employee works more than 5 hours. You're seeing a table here of how many hours, how many meal breaks they have to have. One thing I want to note and that you want in your handbook is that meal period has to start before the end of the 5th hour. So we're logging that meal period at 4 hours and 59 minutes on their time record. Whether that be on a time card or on a timesheet, we're recording that to be before that 5th hour. And failure to do this is also that 1 hour penalty pay. Okay. So just to wrap up this area here, the meal and rest policy tips, you should make sure that you allow employees to leave the premises on their rest, on their meal periods. Employees have to be at workstation promptly at the end of the break. So you can include a policy that says, hey, look, you can do whatever you want. Just make sure you're promptly back at your workstation at the end of that break, or there's consequences for that. Employee must notify supervisor or document any missed breaks and reason why. So on the time record, it's a great idea to include something like employees, I took every single rest break that I was eligible for. I took every break and trying to say meal period that I was owed. And if I wasn't, I'd let a manager or supervisor know. That's great to have some sort of check off, or if your time record can have something like that, even better. And then a rounding reminder, we do not round any kind of meal period. It's a 30-minute meal period. It cannot be rounded. So if an employee is clocking in, you cannot round it to 30 minutes. Make sure that we're not doing that and that we're being compliant with our meal periods, so that being recorded. Let's move on to workplace benefits. We all love workplace benefits, right? And we should highlight these workplace benefits. So if you offer some pretty cool, there's some pretty nice benefits out there like Flex Fridays and Casual Fridays or whatever it might be, or work from home, let's highlight those, but let's do it in a compliant way. And we want to stand out and, you know, set us apart from other companies, because we're in, sometimes we're in competition with these companies. So we want to make sure that we highlight these, but we're also balancing them with expectations. And so that's what this next section is kind of about, is making sure that we're laying all this out. You want to have your vacation policy in your handbook. It's a really good best practice here. We want to make sure that you understand that vacations equals wages, meaning you can never lose your vacation. We can put a reasonable cap on vacation, but in California, it's not even legally required to have vacation. But what California says is, if you're going to offer vacation, you have to follow the policies for vacation and be in compliance. So let's make sure you do it right. So, and in California, we're accruing for every hour we work, we have a vacation time that's owed to us. So if we're going to do vacation, that's the way we got to do it. For every hour you work, you're accruing a portion of vacation. Now there's no use it or lose it policies, right? We're not going to say you're going to lose your vacation, but we can put a cap. And it does need to be reasonable. So that cap can't be, I earn 40 hours in a year and I cap at 40 hours. It has to be at least time and a half. In fact, now we're seeing double time for that reasonable cap. So I earn 40, yeah, and I can accrue up to 80, or at least that 60. So making sure we're spelling that out. That consistency is key, that we're being consistent on when we can take vacation. How do we take it? Do we need to give you notice? How much advance notice? Because we know those employees who abuse this vacation policy, we're going to want this policy to say, you can't do that. You had to ask me at least 2 weeks in advance, so I'm not approving your vacation. That's why it's important. Must be paid out at termination. Don't forget, we're not losing our vacation ever. So if we leave the company, whether it be at day 6 months or a year and a half or in 10, we have to pay out whatever has been accrued up until that day. And personal days, floating holidays, I know these sometimes have been very popular in the past, less so now. And the reason why is because personal days and floating days in California are treated as vacation, meaning we have to pay them out at termination if they were not taken. And a lot of times employers don't do that. We don't track them. And so there's special wording that needs to be done if we're not doing that. So give us a call into the hotline if you have questions on personal days or floating holidays. They have to be treated differently. In fact, most employers are just increasing their vacation bank and doing away with floating holidays altogether. So again, give us a call for more specifics on that if you're going to include it. Let's talk a little bit about drug-free workplaces. We do recommend you have these, even if you don't do pre-employment drug testing, which I know a lot of employers are moving away from. We still want you to have a policy that says we are a drug-free workplace, meaning you cannot come on the premises intoxicated, alcohol or drugs, and this is what we can do if you do. So have a policy in place. That's very important. We've had a lot of calls and they're very alarming and very concerning when it happens. I have an employee who, looks like they are just high and they're acting peculiar. What can I do? Well, do you have a policy on that? So we do highly recommend it for all employers, and it is required to inform your employers before you can, employees, I should say employees, before you can test them for reasonable suspicion. So if you do suspect they're under the influence, there's a lot of things that will come in place. And again, give us a call into the hotline. That's a great place to do that. If you're a member of CEA, we have an entire toolkit associated to drug testing and in a reasonable suspicion way of what to look out for, guidelines, checklists for you to do before you send them out. So there is no law. I know we have our cannabis law, which we're going to talk about next, but there is no law that precludes disciplinary action against employees who are under the influence while they're at work. We still are okay to do that. You cannot be under the influence while you're at work. There are substance abuse, but not on the job use protections under the ADA, under our Fair Employment Housing Act, and the Labor Code protects employees who may be using legal drugs. However, they cannot be using while they're at work. So let's talk about those cannabis use rights here too. There is a new Fair Employment Housing Act protected class. Remember I showed you all those protected classes? Well, cannabis is one of those. Employers cannot discriminate or take adverse action against employees for using cannabis while off the job and away from the workplace. So if you become aware that someone is using off the clock, you just became aware, but you cannot use that against them, okay? It does not permit an employee to possess or be impaired by cannabis while on the job. How will I know, will you say? Well, you're going to follow your policy on reasonable suspicion is how you'll do that. There are exceptions, of course, to building and construction trades when testing is required. We can also reasonably suspect the employee, we're not sure what they're under the influence for, but go ahead and we're sending them to our testing site. Make sure that when you send them to the testing site that they're including the correct way to test for cannabis, because we cannot test for the active ingredients in cannabis that says an employee, or we can test for the active ingredients, but it's illegal now to test for something that might be included, the residual from cannabis in the test. So make sure that your drug testing facilities are testing correctly, because it may be illegal for you to test for certain types of cannabis tests are illegal. Okay, let's move on to discipline and our suggested discipline policy, because we want you to avoid what we call a lockstep disciplinary process. We want to include policies on disciplinary process, however, not a here's what we're going to do. It's more of a guideline, so we'll present discipline as a guideline rather than require progressive steps, meaning we have options available to us, such as a suspension or a verbal warning or a performance improvement plan or a final written warning, but we don't have to follow certain steps for everything. We're free to say this act was egregious enough to terminate on the first offense, or maybe this is going to warrant a verbal warning. So make sure that we're not using discipline as a guideline. Reiterate that the employment is at will and that disciplinary action doesn't alter that at will status. Some suggested languages that you use, and we want you to include this in all your disciplinary, whether it be a verbal warning, a final warning, a suspension. Make sure you include violation of any company policy, either written or otherwise, may result in disciplinary action up to and including termination. That kind of covers you. It's a great little quote that covers you for everything, and you can point to that depending on what you're going to do next. We have some integrity policies that are really important too. They define the expectations and restrictions of your employees and can be valuable in what's acceptable and what you deem as unacceptable behaviors, as well as supporting your misconduct terminations if you're terminating for misconduct, which sometimes we have to do. And that's going to be really helpful if you're fighting an unemployment claim. So really good to have these integrity policies. Some of the most common integrity policies that you should include in your handbook are here that you're seeing, especially the open door policy. You want a statement that says, we have an open door policy, come to us. Here's the steps that you can take. You can go to your supervisor or the next level supervisor or management, or you can go to HR at any time. These are important to have because we want them to come to us internally versus their friend who knows a little bit about law, or the internet, which has ads for plaintiff's attorneys. So we prefer them to come to us when they have concerns versus somewhere else, okay? We want to have conduct policies. Attendance ones are really important. And I know sometimes our attendance policies are very generic or open-ended, and that's okay. You can still work with those attendance policies. Maybe that's because, you want a little wiggle room. And other people have a very strict attendance policy. Whichever one you're following, just make sure you're consistent. We talked about that drug and alcohol testing. Workplace violence is huge now. We know we have to have a separate workplace violence prevention plan, but we want to mention the workplace violence prevention plan does not need to be in your handbook, but we want to mention it in a safety way, right? We're talking about safety, we're talking about workplace weapons, all these kinds of things, and we're also saying that we have a separate workplace violence prevention program. And we'll talk a little bit about that towards the end here. We wanted something on electronic communications, no solicitations, because we want to avoid union avoidance there, so no solicitation. Dating in the workplace, and of course, outside employment to address that. This is the primary workplace, and we want you to spend your time on this primary job. A few more suggestions, companies, so there's so many, social media accounts, what I can and cannot say on social media. So maybe a mobile phone device, you should use it and get reimbursed for it, or do not use it because we're not going to reimburse you. You are not expected to use your mobile device for that. What do we do about after hours? Company vehicles, gas cars, do we provide those? Company property, reimbursement policy is another good one. Personal vehicle use, do we reimburse for mileage? How much? All those kinds of things, very important to lay out. I'm going to talk quickly about the Stericycle decision, the NLRB, the National Labor Relations Board. This is fairly new, and this is a decision that may impact employers out there because it's a challenge workplace rule that any kind of workplace rule will be presumed unlawful if it has a tendency to chill employees' exercise of their rights to discuss wages and other terms and conditions of employment. So we call them the Section 7 rights. And so your rules, your policies that say you can't talk to each other, or we don't want anything that might make us look in poor light or something like that. There's some policies that are written on there restricting their use of social media perhaps, or restricting them from criticizing the company or having any kind of negative comments towards the company. Those kinds of policies, be careful. with them, because if this new rule, this Stericycle decision, says if you are kind of silencing your employees from talking about working conditions, talking about wages, then that can be illegal. So it places more scrutiny on your rules, on your policies, and it's going to apply to everyone, even if you're not in a union environment. This is also for private sector employees. And this is going to be hard. Employers have to prove that the policy they have in place, that wasn't the intention. You know, we're telling them to behave civil or maybe not to be insubordinate, but the way we write these policies, the way we say them, the way we work on them matters. So again, this is something worthwhile to look into. If you have certain policies that restrict employees, never restrict them from talking about their wages, but things like, you know, acting civil or using negative comments, we like using those kinds of things. Just check it. Make sure. You might want to talk to your attorney about whether this is going to be seen as unlawful. Do not include in your employee handbook any kind of probation periods. I know they're popular, employers love them, but remember, it's kind of contradicting to the at-will statement, because if we say you have a probation period of 90 days, we'll see how you do, but after 2 days, we know you're an awful employee, we want to get rid of you, our at-will statement is going to help us. So it kind of contradicts each other. So check into that. You know, you can say we're going to have some sort of training period of 90 days, but maybe not call it probation period. Be careful with those lockstep disciplinary approaches. Do not include policies that have a tendency to frequently change, and then or policies that imply any kind of job security. Consider an employee action hotline. It really reduces liability. Having another outlet, it kind of serves with that open door policy. They're fairly inexpensive with CEA. If you're not a member, they're less than $1,000. If you are a member, they're $699 for the year. So another tool for you to use to avoid any kind of, you know, include that open door policy, but also we want them to stay with us versus a labor law attorney. So to kind of recap here, because we're almost on time, check your handbook for any kind of leave of absence your employer might be subject to, and include those on there. Any post-accident or reasonable suspicion drug testing policies, rest meal periods, because that's that low-hanging fruit that plaintiff attorneys will go for. Include your harassment policy, gender-specific references, so we don't want to say, you know, she can wear this or he can wear that. Our Fair Employment Housing Act is gender neutral, so just say employees can or they can. And then make sure you're checking that National Labor Relations Act language there too. A few reminders here: make sure you review your handbook, distribute it, because I know some of you stay on that handbook and we never give it to the employees. We need those acknowledgments, okay? And nothing happens that they don't know about it unless they sign for it. And then follow and monitor for its effectiveness. If this policy isn't working, change it. And train your frontline management, your lead supervisors, all of them on that handbook. Reminder to just have those labor law posters fully put up, that you have your injury illness prevention program, and that you have a workplace violence prevention plan. Those are all required. I think we had COVID-19, but we don't have to have that anymore, which is fantastic. So remember, if changes are required throughout the year because suddenly something changed, you can have, you can pull it out, that specific policy, and replace it. You can do a complete revision. You can even pen and ink it. Just make sure you get acknowledgement that that's been done. Thank you so much for your attention today. I know this was a lot of information. You will have the slides there at your disposal so that you can reference them. We do have our training codes, and while I put those up, I will give it back to you, Anna, and thank you, Virginia, for handling that Q&A as well. Thanks so much, everyone.
All right. Thank you, Astrid. Thank you, Virginia, for managing that Q&A. So as you see on the screen, we do have some training codes. If you're joining us for HRCI, your code is 706131. SHRM code 25-YME62. If you don't know what to do with that information, go ahead and shoot us an email, ceainfo@employers.org, or you can always call your complimentary HR hotline. I see a request here about slides. I'm going to drop that into the chat one more time. Let's see if I can do it while I'm speaking. Let's see if I can multitask here. There we go. Sometimes if you are not joining from a desktop computer, if you're on mobile or in like a tablet, sometimes it doesn't show up. So if that is the case, LP, if you are joining us from that method and you're having trouble, just go ahead and you can message me your email and I'm more than happy to send it that way. As Astrid mentioned, we do have membership plans available for as low as $125 a month. If should you need more support than the already amazing support that we provide on the HR hotline. So I did just drop the link to that page into the chat today if you'd like to consider that for your organization. And then I also did drop into the chat a link to that that survey that I mentioned at the top of the hour. So this is 5 questions, about a minute, but this is how you share your feedback about today's training and suggest topics that you'd like to see in the future. So with that, I want to say thank you again to Astrid and Virginia for sharing your time and your expertise today. Thank you all for sharing your afternoon with us and having such great questions, such great engagement today. And I think we lost Sev, but thank you for sponsoring today and for everything that you do for Glendale employers, Sevic, and your entire team over at Glendale. I have I've got some emails to send out, so I will get that done today. Sorry about any issues with accessing those slides. And also, Sevic and his team are going to be following up with a link to view the playback. They're going to have a link to register for the next training, and then I'll make sure that they include the PDF so that you'll have everything in one handy dandy email for you. So don't worry whether it comes from me or whether it comes from Seb's team, you will get the PDF of today's training. With that, I want to say thank you. Sorry about going a couple minutes over, but thank you for sharing your afternoon with us, and we look forward to seeing you on the next training in July. Cheers, everyone.